Good morning, or I think we'll make a slow start. There are people just continuing to join the webinar. We've got a lovely amount of people here this morning. It's great to see so many of you having joined us. My name's Alice Reeve, and I'm joined today by my colleague Mark Stevens. Our aim today is to run through some employment law developments that we're going to see primarily over the next few months or so. We're going to start with flexi working, look at the right to request a predictable working pattern. Then Mark's going to take you through a range of the family-friendly rights changes that we're going to see, and finish off talking about holiday. There'll be plenty of time to ask questions at the end, and so please do put any questions that you have in the Q&A box. We're going to record today's session, so you'll have a copy of the recording available to you as well. And yes, any technical issues, please do put it in the chat box. I can see that some people are raising their hands, but the format doesn't allow me to see who that is. So please do pop your query in the chat, and my colleague Ellie is really happy to help anybody who's there. It's designed very much to be a quick heads up today of those changes, but yeah, happy to pick up any particular questions that you may have if you pop them in the Q&A box as we go. So we'll make a start. I think we've got most people with us. We're going to start with just looking briefly at the changes in relation to flexible working that are on the horizon. These appear to have been knocking around for a long time, but we're finally seeing the change in law, which is taking place on the 6th of April. So we're seeing a new piece of legislation and some regulations, as well as some accompanying ACAS guidance and an ACAS code of practice that are all going to take effect on the 6th of April. I think it's worth saying right at the beginning that what they don't do is fundamentally change the principle of flexible working that has been around now for around 10 years. Actually, it was 2014 that flexible working came in, and you probably all know that that essentially gives employees the right to make a request to work flexibly, but as an organisation you're not obliged to agree to that. You can reject it if you've got one of the prescribed business grounds to do so. And the changes that we're seeing don't change that. They still only give individuals the right to make a request, and there isn't a change to those 8 prescribed business grounds that you're able to use to reject a request if you need to do so. So what the changes are really is a change in scope and some procedural changes as well. So just having a little look at those, we've outlined on the slide the main procedural changes that we'll see. So to start with, you're probably aware at the moment that individuals have technically only got the right to make one request to change their working pattern in any 12-month period. That's changing, so they'll have the right to make 2 requests in any year. So I think most people on this webinar are HR practitioners, so potentially has the scope to significantly increase workloads, or for people to have the second bite of the cherry if they've gone right through the process once, and to put in a request once that's finished as well. We'll also see a reduction in the time to make the decision. So at the moment, again, you probably know that you've got 2 months of a decision period from when an employee makes the request to actually it's to the end of the appeal, the end of the process. At the moment, that's 3 months, and it's going to reduce to 2 months. 2 months still feels like quite a long time, but actually we all know in practice that that goes really quickly, and particularly I know we've got quite a few educational organisations on the session, and if you get a request, you know, at the end of June with holidays, that 2 months is calendar time, so it gets used up really quickly. And particularly if you're going to reject a request or it's going to be contentious, you really don't want to be breaching the time limits. And we do see that where there's been a breach of process, it encourages, you know, challenge. So do be really mindful of that. You can extend the time limits with agreement with the individual, but you will need to get their clear and express agreement in writing. Otherwise, you'll need systems in place to make sure you can deal with it. One of the changes which is perhaps interesting is that at the moment it's good practice, and it's strongly encouraged that if you're going to turn down the request, you'll have a meeting with the employee, but that's now enshrined in the legislation from April. So ACAS is clear that if you're going to turn down the request in any way, so unless you're absolutely agreeing to it exactly as it's been written down, you need to have a meeting with the employee. There's no statutory right to be accompanied at that meeting, but again, the ACAS code strongly advocates that you would allow a colleague or trade union representative to accompany the individual at that meeting. That meeting will take a lot of important things to go through the reasons that you're considering turning it down, and use it as well to explore all the potential alternatives. And I think what we see in practice is that if you are going to reject a request, if you can offer some alternatives or appear to reach a compromise, that's often how situations are resolved. The other change that we'll see in terms of process is a bit irritating, I think. So one of the things at the moment, employees have to start the process off by making a request, but they are required to consider the impact of their request on the organisation and how that might be overcome. I think that's really useful because it just gives them a requirement to think about it and just think about the organisational and operational pressures, but that is going sadly. So I think the government felt that employers were best placed to understand the impact and how they might be overcome. So although the employee still has to fill in the form, they don't need to think about how their request may be accommodated. So there are all the process changes, and obviously you'll need to update your policies from 6th of April to take those into account, and think about those who are dealing with flexible working requests to make sure that they understand the changes that are in place, in particular in relation to the time limits for dealing with them. But probably the most significant change, and the one that's got all the press attention, is the change so that this becomes a day one right. So at the moment, you'll probably know that employees have got to have 26 weeks, 6 months qualifying service before they can make a flexible working request. So that has changed, or will change from 6th of April, and individuals can make a request from the start of their employment. It's quite interesting. There was quite a lot of debate when it came in as to whether it should be around, from advert. And actually, I would absolutely encourage that. And the ACAS, the forward, which is to the ACAS Code of Practice, recommends that you do think about, can you have flexible working arrangements or any flexibility when you're scoping a job and when you're advertising it. And I think there's some data from studies to say that actually you increase the number of applicants by, I think it was 30%, if you have a suggestion that flexible working could be accommodated in a job advert. So it's definitely worth thinking about it at the beginning. Obviously, if you conclude that you do need full-time cover, that's absolutely fine. You advertise your full-time job. If someone arrives day one and they make a request to start later, reduce their hours, work from home, any of these potential flexible working arrangements, you will absolutely need to consider it, and you will need to go through your process in exactly the same way. You'll need to have that meeting to consider it and reject it. But it's possible that you'll have stronger business grounds if you've thought about it and you've clearly demonstrated the need for the full-time working arrangements that you've set up in place. And of course, you could always say that you keep it under review or look at it again once the employee has been inducted properly and settled in to the workplace. As I mentioned, as well as the law, we've got a new ACAS Code of Practice coming in. It's pretty short. I think it's 3 pages and about 14 paragraphs, but that will have statutory effect. And it sets out some of these principles, but also the right to appeal if you're going to turn down a request as well. So it's worth familiarising yourself with what is quite a straightforward document as well ahead of those changes coming into place. I'm going to move on from flexible working to, we thought we'd mention this just because it sort of sits side by side with the flexible working regime, although unlike, I think, all the other changes that are in effect from 6th of April this year, this one is not an April change, but we're likely to see it in September or October this year. It has received royal assent, and this is the right for individuals to request a predictable working pattern, and this applies to anyone who's got unpredictability in their contract. So that may be a fixed term that's less than 12 months, or 0 or variable hours. And it's essentially like the flexible working regime in reverse. They'll be able to put in a request to have a more predictable, consistent working pattern. So, for example, if they're on 0 hours, variable hours, to ask for a predictable part-time 3 days a week or however many hours a week, or an annualized hours contract, for example. It looks like the flexible working regime, but it does appear that rather than this being a day one right, they will need 6 months qualifying service. And again, they will put their written request in, have a 2-month period to make the decision. You'll have to meet with them to discuss it. We'll have more detail. The consultation on this finished last month. I think it was the middle of January sometime. And so we're likely to see some regulations and potentially some ECAS guidance as well. But it is potentially an interesting change. And I think at the moment, quite a lot of the work on our desks is around looking at efficiencies and looking at operational efficiencies. And often they are gained by fixed term contracts when you're not sure about whether there's a job going to be permanent or not, whether you're going to have the budget, looking at using some flexibility in your contractual arrangements to meet the ebb and flow of work. And actually this, sort of gives employees the right, and agency workers as well, the right to say, hold on, actually we want this to be more predictable. And so we may see, it'll be interesting to see whether we see much take up of this and how difficult it is to deal with it on the ground as well. I'm now going to hand over to Mark, who will pick up some of the family-friendly changes.
Thank you, Alice. Good morning, everybody. The first family-related right that I wanted to talk about is something that comes into force relatively soon. So as of the 6th of April 2024, employees will have a new right, excuse me, to take unpaid leave to give or arrange care for a dependent. Dependent does not have to be a family member, it's just simply somebody who relies on them for care, where that individual has a physical or mental illness or injury that means they're expected to need care for 3 months or longer, or a disability as defined in the Equality Act 2010, and that we're all familiar with that definition, or that they have care needs because of their old age. So quite a sort of wide definition, I suppose, of who might be a dependent. And the right itself allows somebody to take up to 1 week of unpaid leave every 12 months, every 12-month period. Now, a week can be split. It could be that the individual takes the whole week off at one time in one block, or they could request to take individual days or half days throughout the 12-month period. So this is a similar right, although of course it's different to the parental leave right that many will have already come across. As a right that the parents of children under the age of 18 can take unpaid leave in order to undertake childcare. But so it's similar to that right, but of course it is different. There's a obligation for the employee to give notice of their intention to take that leave. So the suggestion is, though, that the request doesn't need to be made in writing, and also that employees don't need to give evidence of their dependents' care needs. This can again be contrasted with the right that we'll all be familiar with, where individuals can take emergency leave to care for dependents. That's a separate leave right that already exists. Employers can't refuse a request for carers leave, but can, in principle at least, ask the employee to take it at a different time, but they would only be able to do that where they can show that the employee's absence would cause serious disruption to the organisation. So that seems to me to be quite a limited set of circumstances. Obviously, an important new right that all employees will have, they will be protected against being subjected to a detriment, so being treated less favourably because they've availed themselves of this new legal right, and also protected against being dismissed if the reason for their dismissal is the fact they've taken or requested this leave. As the slide says, no qualifying period, so somebody could take that leave shortly after starting their role. I suppose the immediate action, start to think about policies and procedures that are already in place. To what extent do they need to be amended to directly refer to this new right of carers leave? As I say, coming into force on the 6th of April 2024, so less than 2 months time. If we move on to the next slide, thanks, Alice. This is a different type of family-related right. This isn't due to come in for some time, actually. This is a change that will take effect in 2025, in April 2025. So we've got a year to prepare for this. But this right of neonatal care is brand new. There's currently no legal right to leave or pay for employees whose babies require specialist neonatal care. What that means is that, at least for the moment, and obviously up until April next year, staff who might need to take additional time to care for a baby who's admitted to neonatal care would need to use their statutory maternity leave, paternity leave, adoption leave, shared parental leave, or I suppose annual leave, in order to provide additional care for babies who are admitted to neonatal care. Of course, that's created a situation where in some cases parents exhaust their entitlements to leave before the baby is discharged from a neonatal care in hospital. So this new legislation, this new act, will look to address this issue. And what the legislation says is that employees can have up to 12 weeks leave and statutory pay during that additional 12-week period. To be eligible for that leave, the parents will need to have had a baby who's been admitted to neonatal care within 28 days of birth, and a baby who stays in hospital for at least 7 days. Again, there's no qualifying period for this entitlement. When we talk about pay, we're talking here about the rate of pay that's the same as statutory maternity pay and statutory paternity pay, and that's subject to certain minimum earnings and service criteria, again in the same way as SMP and SPP. The way that this new right will work, it seems, is that employees will be able to add that additional up to 12-week period to the end of their other statutory family leave. So it suggests that a mother who's entitled to 52 weeks maternity leave would, subject to meeting the eligibility criteria in terms of their baby being admitted to neonatal care, could add that additional 12-week entitlement at the end of their maternity leave. There's still a little bit of detail that needs to be provided in terms of eligibility and how this will work in practice, and I suppose around notice requirements. What information will need to be given to employees and when. And I anticipate that will come through over the next 14 months or so before this new right comes into force in April 2025. Clearly, you need to think about things now, or at least over the coming months, because, again, policies and procedures will need to reflect this new entitlement so that individuals are aware of their rights and what entitlements they will get during that additional period of time. And I think one of the key questions will be for those employers who offer enhanced contractual pay during periods of maternity leave or paternity leave. What will the impact of this new right be in respect to those paid periods? To what extent will that additional 12-week leave be subject to an enhanced contractual payment? So something definitely to think about now, albeit the law won't change for at least another year, April 2025. So if we move on to the next slide, the next slide deals with another right that that doesn't immediately result in change, but is something we'll need to think about, because the redundancy pregnancy and family leave bill obtained royal assent in May of last year, 2023. What this legislation seeks to do is provide protection for pregnant women and those returning from family leave during redundancy situations. The law as it currently stands says that if a woman who is on maternity leave, or an employee on adoption or shared parental leave, is in a redundancy situation, they have additional levels of protection. We'll all be familiar with the need for employers to think very carefully about an employee on maternity leave's position in a redundancy situation. There's an obligation to offer a suitable alternative vacancy to that individual where that vacancy is available. And we'll all again be familiar with those with a heightened protection that an employee on maternity leave obtains. They effectively are moved to the front of the queue when looking at those alternatives to redundancy. They're prioritised ahead of other colleagues and effectively have the first right of refusal for those roles. And the risk is significant, because if an employer fails to do this, then that employee could bring an automatic unfair dismissal claim. Some time ago, I think back in sort of 2019, the government began looking at whether this protection was enough and whether it needed to be extended. And this is what this legislation really seeks to do. Effectively, it provides that same protection that I've just talked about to pregnant women and women on the return from maternity leave. Again, this legislation is subject to further regulations, and it's likely that there'll be some new detail. And again, this isn't a change that's going to come into force immediately. What we understand is that effectively a woman who notifies her employer of her pregnancy after 3 months and then takes 52 weeks, 12 months maternity leave would effectively be protected for a total of 24 months, i.e. 6 months during pregnancy, plus 12 months during their maternity leave, plus a further 6 months protection upon their return to work. So that 24 months can be compared with the current legal position, which is that the protection is provided for only 12 months, the 12-month maternity leave period. So that's going to mean quite a significant change, I think, for employers who are thinking about redundancy situations. Obviously, it's not in force now, and there'll be more detail around this, but it's clear that where employers are looking at restructuring teams, looking at making people redundant, it will need to take additional consideration of those employees who it knows, who it's been told are pregnant, and also after their return from maternity leave have been have recently taken that mat leave. So there'll be additional consideration, as is currently the case, around what alternatives are there to to redundancy, what vacancies might there be. So that's the that's a additional protection for women, for people about to take maternity leave or returning from maternity leave. There's also some additional protection now, or some changes in relation to paternity leave. So this is a piece of legislation which actually we do need to think about quite soon, because this is something that will apply from the 6th of April of this year, 2024. Paternity Leave Amendment Regulations 2024. Under the current legislation, those eligible employed fathers and partners can take either 1 or 2 consecutive weeks of paid paternity leave within the first 8 weeks following the birth of their child or adoption placement. So that leave is quite restrictive in terms of how it can currently be taken. Can only taken in sort of one block of 1 or 2 weeks. If they take one block on the birth of the child, there's no opportunity to then if they take 1 week on the birth of the child, there's no opportunity to then sort of take the other week later on after the birth. That's all going to change now, basically, because leave, once these regulations come in force, and they'll come in force for any babies who are whose expected week of childbirth or the adoption placement begins after the 6th of April, the law will now be that fathers and partners can take their leave as 2 1-week non-consecutive blocks, and that the fathers and partners can take that leave at any point in the first year after the birth or adoption of their child, rather than is currently the case, which is that they have to use that paternity leave within at least the first 8 weeks after birth or adoption. As the slide explains, there's a reduced notice requirement, only 4 weeks notice. Notice needs to be given for each period of leave, I suppose, to reflect that arrangements at home may be changing, and time needs to be taken at relatively short notice, and the proposed dates can also be varied again here on the slide by giving those 28 days notice. So again, an area where there's almost certainly some policies and procedures that people have in place and be thinking about already in terms of how paternity leave works. They're going to need to be updated to reflect the way that fathers and partners can now take that paternity leave, and in particular can have that extended period of time up to 1 year to take that leave, perhaps in its 2 weeks or in different blocks during that period of time. So lots of change, some of it pretty immediate, and other things more on the medium to long-term radar. I'll hand back now to Alice to touch upon some of the holiday pay things going on.
Thanks very much, Mark. Yeah, we're just going to finish off with a quick update on holiday pay. A number of you will have been with us through the background to these changes, and we thought we'd reached the end of the saga, but not quite. So most of you, I think, will recall the lengthy litigation that was the Gazelle and Harper Trust, which was brought by a peripatetic music teacher, essentially challenging the statutory entitlement to paid leave under the working time regulations, which provided that anybody who worked all year round would get 5.6 weeks worth of holiday, and that had always been interpreted by employers and ACAS and the government themselves as enabling employers to prorate that where individuals worked flexibly or part of the year. The courts, it went right through the courts to consider whether that was the case, and identified that although that perhaps would have been the intention, that wasn't what the law said, and that the working time regulations essentially, although they enabled prorating for somebody who worked part of a week, so 2 or 3 days a week, they simply failed to deal with what happened if somebody worked for part of a year. So we got the Supreme Court judgment in that line of litigation in July 2022, and from that point on, we were aware that the working time regulations essentially gave everybody who was employed, who worked throughout a whole year, the right to 5.6 weeks holiday paid at their average weekly pay. And clients, and many of you on this call, took action to look at those arrangements and correct or rectify them in line with the understanding as promulgated by the Supreme Court. Perhaps then, slightly out of the blue, we got some government consultation, which has now been passed as regulation, which essentially corrects that what could be seen as anomaly and applies specifically to amend the working time regulations for those on variable hour or irregular hour contracts, and those who work part year. The regulations take effect from the holiday year after the 1st of April 2024. So for some of you, that may be the 1st of April 2024. For many others, the educational organisations on the call, it's probably 1st of September 2024. Some other people, it will be 1st of January 2025 if you work to calendar years. So the new regs apply for your next holiday year, and so you'll need to understand when that is and when that's coming to pass. And helpfully, for those people who work on casual contracts, variable hours, you will be able to now prorate their holiday entitlement. And actually, the regulations go quite a lot further than that. And they say that you'll be able to go back to using the 12.07%, which is essentially the it's the calculation which equates to the 5.6 weeks. It's the percentage. So that if someone works for an hour, they get 12.07%. On top of that, that equates to their pay, their holiday pay, that they're entitled to do that. So you'll be able to consider whether you want to go back to that, what's been working well, and implement that for the next holiday year. The bit that's still uncertain really relates to the part year workers. So those people who are only working for a proportion of the year. Again, it's absolutely clear that the regulations allow you to prorate holiday pay where somebody is only working for and is only paid for part of the year. So if you've got somebody who's, say, on a bank kind of contract, but you call upon them and they do 2 months worth of work, for example, and they're paid for that 2 months worth of work at the time, you'll be able to prorate the holiday for that period and pay them accordingly. If they then have no pay for the next few months, then they come back and they do another month, you can pay them for that month and you can prorate the holiday again for that month. And you can do that in a variety of ways, either at the end of each period or at the beginning of the holiday year, or however you choose to do it. The category that is still perhaps not as we would expect are those people who are on annualized contracts. So they might work part of the year. And again, given the delegates we've got today, the classic sort of people who work through term time only, or a number of weeks a year, say 34, 39, 40 weeks a year even. But in fact, they're paid for those number of weeks, they're paid for their holiday weeks, but then it's calculated in an annualized salary. And in fact, they receive the same pay each month, whether they're working or not. We had anticipated that the regulations would cover those individuals, and so that when you're considering what the holiday element was that you're adding in to their pay calculation, it would be prorated from the full-time equivalent amount based on the proportion of the year that they worked. But we have now seen some government guidance which is really explicit that the regulations are not intended to cover people who are paid all the year round. It's only where you have periods where people are not working and are not paid that you can benefit from the prorating principle. So that category of staff, based on the guidance, would still now be entitled to the full statutory entitlement of 5.6 weeks pay based on their average weekly pay. So, you know, it's probably a classic case of 2 steps forward and 1 step back. The law is set out in the regulations, but the guidance, which is the government guidance, is non-statutory, but obviously it interprets those regulations and explains how the government understood them to be applied. So at the moment, I suppose the cautious approach would be to reflect that guidance and to continue, which for most people will be maintaining the status quo for that third category of staff, for those people who are on annualised contracts. Unless we see the guidance being reviewed or challenged. I'm not sure that anybody particularly would want to take on a test case to see whether the guidance is correct interpretation of the regulations. We're essentially advising that all employers look at the different categories of staff that may be affected by this, and where you have got those people who are on annualised contracts, understand the impact, because you can still prorate the contractual entitlement. What it means is that it can't then fall below the statutory element of the 5.6 weeks. So work out what the difference is, what's it actually going to cost you, and understand the impact. If it isn't very significant, it may be that you simply leave it for now and take a watching brief and see what happens. If it is really significant, one option might be to look at the contractual arrangements you've got in place, and rather than receiving annualised pay, look at paying as they work and having periods where they don't receive any pay at all. But obviously we'll be happy to help with any specific questions that you may have relating to your organisation. I'm sorry, we thought it was a really good news story when we got the new regulations, but you know, we're not quite at the end of the saga just yet. That brings us to the end of everything we plan to say today. Just before we've got lots of questions in the box, so Mark and I are going to be kept busy for the next 20 minutes rattling through those questions, which we will do now. But just before we do that, we just wanted to remind you that well, we do have a suite of documents. I've seen a number of people ask about that in the Q&A. So for those of you who already subscribe to our employment manual or policies or contract documents, yes, there will be an update coming out in spring, so do keep an eye out for that. We also, if you don't and you're interested in doing that, please let us know. We also have a suite of e-learning, and we'll be updating those as well. Perhaps the flexible working one, for example, in particular, which can then be used by your managers to make sure they're up to date with the latest developments. So just wanted to raise that. And if you are interested, I think Ellie has just put a little poll up to let us know. Please do let us know if you're interested, and we'll get in touch with you. And then we'll, thanks very much. And we'll just head over to the questions now. Mark, I'll read them out, and then we'll perhaps, if depending on which area they are, we'll rattle through them. Sorry, go back to the top. Right, they start with flexi working requests, so I'll pick up those, but Mark, please do chip in if you
yeah, of course.
know the answer.
Thanks, Alice.
So the first one is interesting. How do we manage flexible working requests from teaching staff where we're unable to respond to requests until May, because that's when you know what your timetable might look like and the teaching requirements. I mean, schools are really challenging, aren't they, in terms of planning the staffing that you're going to need for the next academic year, because it does depend on both numbers of pupils, but critically those options that are picked. And in fact, May is quite early. Lots of schools I know are still wrestling with the timetable in August. So if someone makes a flexible working request, you've absolutely got to deal with it in the time frame, so that 2 months from start to finish. You've got to deal with it based on the facts that you know at the time. I think there's a lot you can do around management of employees to understand when you are going to be looking at the timetabling. I mean, actually, if you're plotting it in say May or June, it's going to be really helpful to know if people want to change their working patterns in that time of year. Whereas if someone makes a request in September, it's perhaps going to be more difficult for you to accommodate. That's not unreasonable. So actually explaining that to people so that they understand how the timetabling works and when you're more likely to be able to deal with requests is likely to help you, but you will need to strictly apply the process and look at those prescribed business grounds. But yes, if somebody's making a request in October and actually it's going to be difficult at that time to accommodate that because their request doesn't match when the work needs to be carried out, or will impact adversely on the quality of your service, for example, to students, then you'll be able to reject it on those business grounds. Oh, the next one's a process one about flexible working as well. Saying, do employers have to adjourn between the meeting and the employee to consult and make the decision? I mean, as a general practice, yes, I would always close a meeting and then reflect and take it into account. I think if you don't do that, it doesn't really look like you're genuinely listening to what somebody's got to say and considering the representations they make. So I would always recommend that you go to the meeting armed with, this is what we think we can accommodate, this is what we can't accommodate, and this is why. But the purpose is to have a dialogue, to listen to what the member of staff might have to say about that, to explore the alternatives that, the areas of compromise that might be reached, and then close the meeting, reflect, and then make the decision. That isn't a legal requirement, but I think in terms of dealing with it in a reasonable manner, you'd be struggling to establish that if you clearly had got your letter prepped and went to the meeting and just told them at the end that you've not changed your decision. What happens if they request flexible working at interview stage? So from a legal perspective, under the flexible working regime, they are not eligible to do that. And so you would be within your legal rights to say that. You do need to be slightly mindful, nothing's ever straightforward, of discrimination legislation. So sometimes people are requesting flexible working because they have got childcare needs or because they're disabled and need reasonable adjustments. So you'll need to understand why they're making that flexible working request. I would generally recommend that you say that you'll look for the best candidate for the job and determine that, and then if they then want to work flexibly, you sort of address that in accordance with the principles and decide what to do rather than muddling up the two issues. So that you might say, if someone says, can we work flexibly, to say, we've considered that really and we think it's a full-time job, but actually if you want to apply, we'd always be open-minded and consider it, and then do it in the 2 stages, make the decision based on their suitability for the job, and then address whether you can accommodate any flexible working if that's what they want to do. We've covered off about where the documents are. Oh, can we still ask an employee to consider the impact of their flexible working request as part of somebody's internal process? I think, Mark, you could say that it would be helpful if employees thought about their request and the impact and came to the meeting willing to discuss that, but you couldn't make it an essential part of the process or a requirement. I think that's probably right.
I totally agree. I think it's about having a dialogue with an employee, talking to them about how they envisage it working, where they envisage some of the issues might arise, how those issues might be surmounted. So I think it's definitely useful to include it as part of the discussion.
This is a hard question. If someone is currently allowed flexible working changes, can we review and remove them if there is a business case? So potentially, yes. I mean, flexible working only works one way round, that people make a request and generally if you accept it, it's a permanent change to their contract. So if you wanted it to be a short-term change or subject to a trial or review, you would need to explicitly put that in. Otherwise, essentially, you're in a position where that is their contractual arrangement. You can obviously make changes to somebody's contract with their agreement. And so you could always look at what the needs of the organisation were and talk to them and see if you could agree something that better met the needs of the business. And people's needs do change. If it's a flexible working request for children, we all know that it's different when they're preschool to when they're at school to when they get into their teenage years, and that they need different kinds of support. So it may be that somebody's willing to talk to you and agree that. If they're not, then you're in a process where you need to look at whether you need to bring their current arrangements to an end and offer them alternative, and that would be some other substantial reason, dismissal potentially, and you would need to handle that carefully, thinking about what the business reason would be, and also if they had any specific reasons for their flexible working arrangement, again, because it's children or disability particularly, then you would need to take that into account. So potentially yes, but there isn't a sort of set process, and it would be essentially like any other contractual change to terms and conditions. The next question is about the timeline and the 2 months including the appeal. This is an interesting one, Mark. I looked this up recently, and actually, although there isn't a statutory right to an appeal, so the time frame is from beginning to outcome. If you do offer an appeal, you need to have completed the process by the including all of it and the outcome of the appeal letter. So the new ACAS Code of Practice does say that they think employers should be giving a right to appeal. So I think this means that you should plan a timeline, which essentially allows you to invite somebody to a meeting, have the outcome of that meeting, put their appeal in, have the appeal meeting and have the outcome all within a 2 months process, and plot that out. And if that's not feasible, or if the employee asks to adjourn, as we always know that they might say, I can't attend that meeting or my union rep's unavailable, that's fine, but you make it clear that that's okay, but that means that it will mean that the process may take longer than 2 months, and are they willing to agree to that? And that's how I'd suggest you deal with it. So the next one is another schools one, similar to the question we had before, that for flexible working in a school where teachers work part-time, sometimes you don't agree the exact days off until mid-June. I think this probably comes to the predictable working pattern, and I think somebody like that, I suppose what you're saying is they say 0.6 or 60% of work is what their contract is. But in terms of their days of work, they may change every year depending on the needs of the timetable, and you confirm that. I don't know whether they would. I think they probably will fall within an irregular hours work. Well, I'm not sure actually. We've not got the regs, because obviously their hours are set. It's just the days of work that are different. So I'm really sorry. I don't know whether the new bit of law would change that. At the moment, generally, that's fine. But obviously, you still need to be mindful to treat all your employees and part-timers not less favourably. So again, the more notice you can give them, the more explicit you are about what the process is, the better. But that should still be fine. Does the predictable working pattern apply to consultants? So that's an interesting question. No, they apply to all kind of workers, and so that will be directly with the organisation, people who engage with them, so employees and workers. They also expressly apply to agency workers who have got a slightly different route to go via the agency, but I don't think they would apply to self-employed consultants. So it would exclude self-employed consultants, but it would apply to everybody else. Mark, is that your understanding as well?
Yeah, totally. I suppose the risk is, of course, that somebody says, well, I'm not a genuine consultant, I'm in fact a worker. But yeah, I think that's exactly right. It's not something that consultants can avail themselves of.
So then the next question is similar to the one we've had. Can somebody under a permanent contract request with predictable hours require that they work set days? I'm not sure actually. We haven't got the detail. I don't think that is. I think the regs are specifically about where you've got irregular hours, but actually I just simply don't know. I think we'll have to pick that one up when we get more detail, and obviously we'll usually do a session, one of these webinars, when we've got the detail of the regulations. As I say, because it got Royal Assent in September 23, they suggested that there'd be about a 12-month lead-in till the law coming into effect. We obviously may have an election in October, so we'll see what happens in relation to that, but the Act has been passed. The next question is, does this mean 0-hour contracts will disappear? Absolutely not. You can absolutely still use contractual arrangements, 0 hours, variable hour arrangements that meet the needs of your organisation. What it means is that people have the right to request that that's reviewed. And if you still need them to be in that way because of the work pattern and because of the way that it will cost more, it will still be one of the business grounds to reject a request. You can absolutely do that. I think what it will mean is that organisations will have to sort of question themselves, and actually where you've had people who are on, you know, repeatedly on 0-hour contracts or fixed term contracts, but in fact they're working pretty regular hours, then actually it's those sorts of people where you need to commit, I think, to budget and give them more regular contracts, and not continue to use the sort of flexible ones. But there will still absolutely be a place for 0-hour contracts. And Mark, I think I'm going to hand over in a sec because too many questions. Does the predictable working pattern apply to all sectors? Yes, so it does apply to all sectors. Obviously, there will be some sectors where it is perhaps more difficult to accommodate, and you'll be able to reject their requests on their prescribed business grounds. How much notice would they have to give? I assume that's about predictable working pattern. Again, it's that sort of same process, so they would have to make a request in writing, and then you would consider whether it can be accommodated in that 2 months period. Yeah, we've covered that it would apply to workers, but not freelance, but not genuine self-employed people. But as Mark said, you'd have to be careful about where the line is blurred. Mark, question about carers leave.
Thanks.
Is annual leave still accrued during carers leave?
Yes, I think it would be, in the same way as other types of family-related leave, such as maternity leave. And the next question, is carers leave taken as a block of 1 week, or can it be taken as single days totaling 1 week over a year? Well, it's the latter point. It can be taken as single days, up to 1 working week. So if somebody works 5 days a week, then they can take 5 single days a year. If they work 3 days a week, then it's 3 single days. Of course, actually, I think the regulations talk about taking half days. So there's lots of flexibility there for an individual. Next question was, please could you clarify current rights as an employee who needs to take time off to look after a child pre-April? Did you say they can already take a week of unpaid leave per year to look after a child? Yes. Excuse me. You're absolutely right. There is a right already to take up to 4 weeks unpaid leave per year, where somebody has responsibility to look after a child. That's the current position, the parental leave entitlement. That's completely separate to carers leave, but it's similar insofar as it's an unpaid leave entitlement. As I think I mentioned, there's also a right to take dependent leave, emergency leave, which is again an unpaid leave entitlement. That generally is only going to allow somebody to take 1 to 2 days sort of leave to deal with an emergency situation, not necessarily about a child, but it could be. Moving on to the next question. I think it's actually a flexible working question, but I think it is okay to look at revising a policy after that date, or be it need to be effectively ready to deal with the new regime from the 6th of April onwards. The next question is a really interesting one about how this neonatal care leave will work. I think the final comment, would they have to have 13 weeks of maternity leave unpaid and then have the 12 weeks statutory pay as neonatal care leave, is right. Yeah, that I think is how it would work. The entitlement, for instance, for a mother who's taking maternity leave, 52 weeks, of which, of course, the 13 final weeks can be unpaid.
Mark, presumably they could give notice to bring their maternity leave to an end.
Correct. Yeah, that's a really good point.
8 weeks
Yes.
notice, and then take the neonatal leave. I don't think
the leave
neonatal is conditional on having used the full maternity
leave. No, really
leave,
good point. Yeah,
you could do that. You could do both, either or, depending on what the employee wanted to do, to have more leave or more paid leave if they wanted to.
Yeah, exactly. There's a question, if the business uses many casual 0 hours where the work is very unpredictable by the nature of the work, how can we manage this? Well, as Alice says, I don't think there's a need to sort of stop structuring the way in which you engage individuals to provide work. you can still use casual 0-hour contracts, just have to be now live to the entitlement that individuals who are working on that basis have to request more predictable working pattern. Of course, and as Alice says, that there is an entitlement for the employer to reject those requests on the basis of a number of different reasons, including business grounds. The next question was, can an employer offer a father an option of taking either 2 weeks paternity leave and statutory paternity pay, or 1 week full pay during the first week of paternity leave if they forego their second week of paternity leave? I think there's probably need to be a bit careful about suggesting that somebody forego any second week of paternity leave, because that's a legal entitlement that they have. I can see the sort of commercial sense in a bargain. Well, if you want to take 1 week, we'll make sure that that's paid in full, but we can only otherwise, if you take 2 weeks, pay it on the basis of statutory paternity pay, which would be a lower amount. I think we'd still want to be careful about suggesting that people sort of give up their legal entitlement to take that second week, albeit at a lower rate of pay. How will this work with annual leave and potentially neonatal leave if entitled to that? Yeah, again, a good question. I suppose we'll have to see in practice how people take that type of leave. The way I see it would be that neonatal leave can be used on top of, in conjunction with annual leave. So it may be that somebody is entitled to a 52-week maternity leave period, takes their neonatal leave, and then takes some annual leave that's accrued during those periods of time on the top of all of that. So you could see how somebody might be using those different types of leave to be out of the workplace for quite a significant period of time. I do think that's possible.
I agree with that, Mark. It must accrue during neonatal leave in the same way, and they'd be entitled to take it, wouldn't they? So.
Yeah. The next question, and it's something that I've been checking. There are some regulations that have come through, and in actual fact, the protection from redundancy is likely to come in force now from 6th of April this year, 2024, rather than 2025, as I mentioned. So that the regulations haven't been put through Parliament as yet, but the suggestion is that when they do, they will come in force on the 6th of April 2024, providing that additional protection for pregnant women who notify their employers after the 6th of April of this year, rather than 2025, as I suggested. So thanks for that question, and I hope that clarifies that. That's also the same question again there in terms of when that legislation comes into force. I think the next question, what if the baby was born early and the parent hasn't given the 4 weeks notice? So this is in relation to, I think, the paternity leave entitlement. I think you probably approach it in the same way as you ordinarily would do with an individual who's entitled to leave and their circumstances do change. You'd probably try and consult with that individual, talk to them about what their current leave arrangements are and what alternative might be available, whether it's taking some degree of annual leave in addition to the paternity leave. The next question was also about paternity leave. Am I right in thinking that you still have to give notice at least 15 weeks before the expected week of childbirth that you'll be wanting to take paternity leave at some point, but the request for specific dates can be only 28 days? My understanding is that once from the 6th of April 2024 onwards, a father or partner only needs to give 4 weeks of their intention to take paternity leave, and then if they wish to then change those dates, they can give 28 days notice of that. Alice, there's a question here about holiday rate in terms of hourly rate roles only.
I'm sorry, I got kicked out and now I can't read it. Do you mind reading the question really quickly to me,
Oh,
Mark? I'm very happy to
hello.
answer it.
Sorry.
But somehow the Q&A is blocked. And
Welcome
as I
back.
suggested, we're very close to,
Oh,
we're
of
just
course.
over our time. But if Elliot's all right with you, we will just crack on and just finish up really quickly the last couple of questions, and then but obviously if people need to go, please do. Mark, can you read me the question
Yeah,
really quickly?
sorry. So it says, does the holiday rate apply to hourly rate roles only, or all roles, including those on pro rata salaries?
That's really interesting. So basically 12.07 is essentially the prorated element of 5.6 weeks, or the statutory minimum. So you do need to think about what is your contractual entitlement, and actually where you've got a greater contractual entitlement for all year round workers, where you've got people who are comparable doing the same job but on a part year basis or a comparable basis, then they'll need the prorated contractual amount. And so that may be a different percentage that you're using. It should never be less than 12.07%.
Next question, does the 12.07% holiday pay have to be stated separately on a pay slip?
Well, that used to be the position, absolutely, and that was because you technically weren't able to roll up holiday pay, but the law said you could set it off as long as you could demonstrate that someone had actually received it. And the way of doing that was to absolutely demonstrate this is your pay, this is the holiday element. I think our recommendation would be, although that doesn't appear to be a requirement of the new regulations, it's a really helpful thing to do, and you can then absolutely demonstrate what someone's pay is and then what the holiday element is, and that's useful for a whole lot of reasons, to be able to demonstrate comparability, that they're getting their holiday when compared with a comparable worker as well. So although it's not technically a requirement, it's a really useful thing to maintain.
The next question is in relation to carers leave. So it envisages a situation where it asks, would the employee have to be the dependent's sole primary carer? Does it exclude, say, the grandchild from requesting time off to help their grandparent? No, it doesn't exclude that at all. In fact, the carers leave doesn't apply to people who have care responsibilities over a family member. You don't have to be related to the individual who requires care. It's just where there is a care responsibility. So, yeah, grandchildren who are looking after grandparent could avail themselves of that leave. The next question. Paying holiday for people on overtime at 12.07%, what average pay elements should it include?
Oh, well, we might need to. So basically, someone needs to be in the same position as if they were at work. That's generally the position, and we've seen a whole line of case law. So really, when you're paying somebody for their holiday, it should be based on their normal pay, which would include all normal allowances and overtime if that's something that's regularly worked as part of their contractual arrangement.
Yeah, thanks, Alice. So the next question was about maternity leave protection provided to people who are on maternity leave. Envisages a situation where 5 employees are affected, including one currently on maternity leave. Are we obligated to specifically offer the higher level post to an individual on maternity leave? Not necessarily, because the obligation is around where you have a suitable alternative role. That the person who's on maternity leave will have got the additional protection that will now be provided under the new regs, to allow that individual to slot into a suitable alternative role. If this is genuinely a higher level role, then it's appropriate to open it up for applications. And as the question goes on to say, this scenario could potentially lead to a redundancy situation. It's lawful to make somebody redundant in those situations where there is no suitable alternative role for them to slot into. The next question was, can you extend the 2-month period by agreement with the employer? Yes, that does work. I think that's actually covered the next two. The next question was, I missed the difference between carers leave and parental and emergency time off. So unpaid carers leave is a new right for up to a week. That can be over any 12-month period. It can be taken on the basis of half days, full days, or the full week. It's different to unpaid parental leave, which is a right that's been around for over 20 years, I think, entitling parents, people with childcare responsibility, to take unpaid leave of up to 4 weeks during each year. Emergency time off, again, that's not changing. The right to take time off to deal with an emergency involving a dependent. Generally, that entitles somebody to take the immediate time off to care for somebody or deal with an emergency situation that's arisen, 1 to 2 days of leave before generally an employer would ask somebody to do something different in terms of perhaps taking annual leave or availing themselves of another right. The next question. Thank you for this one. We are an SEND college and employ a number of support workers. With regard to flexible working requests, if an employee asks for flexible working to, for example, pick up their own children from school, could we refuse on the grounds that our students need support until the end of their college day?
So potentially, yes, you'd absolutely have to follow your process. You would need to weigh up what your business needs were, and actually the fact that you have a need for continuity of service till the end of the school day may well give you very good reason to turn that down and reject the request. But obviously you would need to consider, have we got anybody else who could cover that work? I mean, I think it is quite hard to recruit somebody to just cover, say, the last hour of the day, and it may be that you can't release them early, but you need to go through, establish what that business ground is, consider any possible alternatives, and then reject the request. But yeah, it should be on solid ground there.
Thanks, Alice. So the next question is, do any of these rights of leave preclude each other? In other words, are all available to the employee where applicable? I think they would be all available to other individuals. Sorry, to employees where it's applicable, where they are all eligible. I don't think they sort of cancel each other out. The next question was about the when the lead protection for people on pregnancy and family leave come into force, and you're right, that is, I think, likely to be the 6th of April of this year, 2024. The next question was, is there any advice when an employee is signed off on stress to care for a child? Sick pay then applies, but how long would we need to allow before starting a capability procedure? Or are there any other options?
Oh, I mean, I'll start, Mark, but Will. I mean, essentially, you treat that, if somebody is signed off with stress, then you need to treat that as a sickness absence, as you ordinarily would. Obviously, you need to consider whether there's anything at work that you can do to alleviate the stress or support them. I mean, it's unusual for stress to be, compartmentalized and have, but you do see it where it's perhaps caused by a bereavement, but often it's multifaceted. And it's caused by lots of things. So you should do your sort of stress risk assessment and work out whether you can do anything to support them at work and any adjustments to help them in the workplace. Otherwise, you can then go through your normal long-term absence process in terms of getting some health advice as to when they're likely to be fit to return. And if there's nothing further you can do and they're unable to do the job that they were employed to do, ultimately that could be a lawful reason to bring their employment to an end.
The next question is for me about the notice of paternity. I think I disagree with Mark about the notice of paternity. I've read it that the employee needs to tell the employer that they will be taking paternity leave in the future, and this needs to be given in the 15th week before the week the child is born. The reduction in 4 weeks is the notification of when the leave will take place. It may be that I'll have to look into this in a bit more detail and perhaps come back to you directly in relation to that one. Thank you. The next question was, are we saying that a term time staff member who is paid annually, equally per month, has a full minimum 5.6 weeks holiday pay, and this can be prorated 34 50 seconds of 5.6?
Yes. Oh no. So actually, based on the Brazil decision at the Supreme Court and the guidance, essentially somebody who's paid annually would be entitled to be paid 34 weeks of work plus 5.6 weeks of holiday, and then you would annualize it. And actually what you can't do based on the guidance is prorate that 5.6 weeks to equate to take into account the fact that they're only working 34 weeks and not the full year. hope that answers that question. But do come back to us specifically if you need anything else.
And
Have we done it, Mark?
well, just to come back to you, I think on this question about the paternity leave, I think it's right, yes, that you're giving that notice of your intention to take paternity leave within that 15 weeks before the expected week of childbirth. But then, as you say, it's giving that 4 weeks notice of when the leave will actually take place. And I think so. I agree. I think with the way that it's framed in that question. So thank you for that. And that is the final question.
Fantastic. Thanks so much for sticking with us, everybody. We've done well to get through all of that. There was a lot of information there. So yeah, please do come back to Mark or I, or your usual team member if you need anything. But otherwise, thanks ever so much for joining us and for your participation. We really appreciate it and hope to see you again soon.